extend my thanks and appreciation that I'm sure all of you share for the lovely reception and dinner we had at BMI headquarters last night. That was a lot of fun. And I still haven't quite figured out what to do with the potato bar, but nevertheless, I thought it was excellent. So we have 3 panels today, 2 before lunch, and then 1 following lunch. And we're picking up this morning with an issue that's very relevant to collective rights management in the United States, and that's the collective management of mechanical rights. And we have a very distinguished panel, and I look forward to hearing their remarks. So I will turn it over to the moderator.
Thank you very much. Good morning, ladies and gentlemen. Or as I learned sort of from practical experience on the flight down here, you don't say ladies and gentlemen, you say folks. Oh. I'm sorry you have to spend these hours indoor in such a lovely weather as we have today. But I think that it will still be rewarding, notably because we have a very distinguished panel to discuss the issue of collective management of mechanical rights. Our speakers are Mrs. Marybeth Peters, the Honorable Marybeth Peters, Register of Copyright. We have Mrs. Laurie Hughes, Vice President, Business Affairs, Music Rights and Licensing, TouchTunes from New York. We have Mr. Steve Marks, who is Executive Vice President and General Counsel, RIAA. Unfortunately, Mr. Rick Carnes, I understand, has been stuck at the airport, so last minute we are very happy to welcome Charlie Sanders, and since he's not in the list of biographies you've had, I'll mention that he's attorney and counsel to the Songwriters Guild of America. He's chairman of World Hunger Year and Artists Against Hunger and Poverty. That's the music industry's social outreach program, and he's a professor at New York University. Of course, we would have preferred to see a real-life songwriter, because it's all sort of the authors who are at the roots of these things. But I mean, okay, better than nothing. Better than nothing. And finally, Mr. David Baskin, who is CEO of the Canadian Mechanical Rights Organization, CMRRA, sorry, and he's also counsel to the Music Publishers Organization in Canada. We will first take a round of statements from members of the panel, and I'll first give the floor to the Honorable Marybeth Peters. Thank you.
Good morning. I'm pleased to be here, and I thank the sponsors for inviting me to talk about an issue that has consumed a large part of my life in the last 4 years. And it's the what we call the mechanical right. And what I thought I would do that could help the discussion, at least to understand the situation in the United States, is to explain how we got to calling the making of phono records the mechanical right and what the issues are today. Obviously, the goal is always efficient licensing, and I think that's why we have collective licensing. Collective licensing was put in place so that you could go one place and get all the licenses that you need. And we can look and see how that has worked in what we call the mechanical right era. In the United States, in the late 1800s, what was invented was a player piano. And player pianos had to have music that was inserted into them, and so they were piano rolls. And certainly if you were a music publisher, you thought you controlled the right to authorize the making of those piano rolls that would bring sounds into the living rooms and into restaurants around the United States. And these music companies actually licensed these rights. They gave them to one company called the Aeolian Company. And another company copied or did the same thing, and a suit was brought. And lo and behold, the courts decided that these piano rolls, or what would today be a CD, was not a copy. They were not copies of the musical composition. that in order to be a copy, you had to visually see the notes. So it was sheet music. It was the notes and the lyrics. So it was visually imperceptible, not a copy. They recognized, however, that the making of these piano rolls should be within the scope of the music publisher, Songwriters control. And so they came up with this thing, well, you have the right to control mechanical reproductions. Mechanical in the sense that this was going to be put in a device. And even today, there are players that you put the digital file or the CD into. So Congress was enacting a new law, and they were being lobbied by the music publishers to basically make sure that this was a right they had. And just before they passed this law, the Supreme Court agreed with the lower courts and said, you got to be able to see the music for it to be a copy. So in 1909, when we revised our law, we created for the first time the ability of the owner of a musical work to have the right to control the making of these mechanical reproductions. Because one company had bought up all of the rights, the Aeolian Company, and this was an era in the United States where monopolies were not favored, Congress basically said, we recognize we need to give an exclusive right. That exclusive right will be exhausted once the copyright owner has authorized the first recording of their work for distribution in the United States. And after that, everybody else can make recordings, can make similar use. So it was the first compulsory license in a copyright law anywhere in the world. And it really was because of the monopoly situation with regard to one company. So we had a compulsory license, and what it said was the user of a compulsory license, the one who was making these recordings, paid 2 cents for every kind of copy. I'm calling them a copy. They didn't call them a copy. Mechanical reproduction of what was manufactured. And that 2 cents stayed in effect until 1978. Because there was a compulsory license, nobody used it. Because the ability to make a recording was there. You could either cut a deal with the music publisher, or you could, under the law, get that right. The way it worked out was there was a license that was issued. An agency came into being that dealt with these licenses, the Harry Fox Agency, and the only thing that the compulsory license for the most part played was it set a cap on the rate. So whatever the rate was, nobody negotiated when you're doing a cover record. For higher, it always was lower. In 1961, the Copyright Office said, we don't like compulsory licenses. They really say there's market failure, and we would like to get rid of this compulsory license, and we suggest that 1 year after this new copyright law goes into effect, the compulsory license should disappear. Who objected? Music publishers. Music publishers had gotten used to the way of doing things, and they thought that this should be kept, and that there still was a need for compulsory license. And of course, the record companies wouldn't object because it made their life easier too. They would always have the ability to get a license. So the license stayed, and the rate was taken care of because there was a mechanism whereby there would be rate adjustments. And once again, practically nobody used the compulsory license, and nobody cared about it. In 1995, the record companies were fighting to get a performance right for digital transmissions. And they were making a very convincing case that the world had changed and everything was digital, and there was digital radio, there were cable systems that were delivering digital performances of music, and they needed a performance right. And as they were getting it, the music publishers said, wait a minute, if stuff's going to be delivered digitally, shouldn't we change our compulsory license to recognize that musical works and recorded sounds will be delivered digitally? So they came up with amendments to the compulsory license that recognized digital transmissions and created a category called digital phonorecord deliveries. And I will not bore you with the definition of what a digital phonorecord delivery is. It is very complicated, it is very long, and within this provision it said that there should be a distinction in the rates between incidental digital phonorecord deliveries and general phonorecord deliveries. I can tell you to this day, we really don't know what an incidental phonorecord delivery is. But in any case, this language was put in the law. And as these online services blossomed, or didn't blossom, and as everybody in the world was basically transmitting music to each other and copying music, it became clear that there was an issue out there. And that in order for legitimate services to be able to compete with the pirate sites or the illegitimate services or unauthorized services, they had to be able to clear rights and make music available quickly and efficiently. Compulsory license always had been done one work. It was title driven. You basically, if you were going to use the compulsory license, you found the owner of a particular song. If you wanted to use 5 songs, you had to, at that point, send 5 of these notices with each title. And guess what? These services needed thousands of songs. And they didn't need them 3 months from the date of release. They needed them soon, because all of the copying was happening soon. So what they decided was, their solution was the compulsory license. But guess what? It didn't work. The way it was set up, it never could work. So at that point, you'd say, okay, there's the Harry Fox agency, it's the collective agency, it should be able to handle all of these things. But it really wasn't set up to handle all of these things. And so there was a call, essentially, to revise the compulsory license. We have not been able to do that because there are 3 parties. There's the record companies, there's the music publishers, there's the online services. And there's a lot of disagreement on what the law should look like, although you heard yesterday that we got close when the online services and music publishers more or less cut a deal. One of the biggest issues is the scope of the rights that are covered by this compulsory license. And you heard a lot about this yesterday. Compulsory license traditionally covers the making, the reproduction, and distribution of a phonorecord, including a digital phonorecord delivery. The way that these are being delivered is through transmissions. The question then is a transmission of a download a public performance? Does it matter if it's a permanent download or a limited download, a tethered download, as you might have in a subscription service? And then there's the issue of what clearly is a public performance, which is streaming, but there are now reproductions that are being made, and they actually travel. They may not stay with the consumer, but those are reproductions, and they are flowing out from the online service. And what about them? And the issue for the Copyright Office is streaming, but for the record companies, not the record companies, the music publishers, the big issue is on-demand streams. And they make a distinction because the economic value is different. They believe, and I agree with them, that if there's an on-demand stream, there is an individual saying, I want this song. And if I can get this song whenever I want it, I don't need to ever buy a digital, a phonorecord. So it will replace sales. Where with regard to a stream, it's pre-programmed, and if you get something, you get it, but you haven't really demanded it. So the question is, with on-demand streams, should the copies that are made with regard to on-demand streams be subject to the compulsory license? Beyond that, there are issues that are in a digital world that are not in a physical world, and it has to do with server copies, it has to do with cache copies, buffer copies. I think there was a lot of agreement on how to resolve this, but not fully. Question is, with regard to collective management, we have the Harry Fox Agency. It represents a lot of people. Unlike the performing rights area, where you have 3 performing rights organizations in the United States, and if you get a license for those 3 people, you are covered. You cannot do the same thing in the mechanical rights area. Harry Fox represents a large number, not all, and not enough. So it isn't quite as simple, which is why in the variety of solutions that I suggested, and I'll just bring it up and let others talk about it, I suggested that in the online environment, there should be a musical rights organization that can basically license all of the things that the user needs. And then you worry later about reproduction, distribution, performance, and who gets what. For me, I have to say, it doesn't bother me that much because the beneficiaries are all the same. Whether you're talking about a public performance or reproduction or distribution, in the music area, you're talking about the music publisher, you're talking about the composers and the lyricists. So it's the same beneficiaries. It's not like it's also the record companies and the performing artists. So this should be worked out. However, I am very well aware that politically, to suggest that there should be this new organization or that existing organizations should somehow get together and make this available was a very difficult thing. And I agree that there was a huge step made going forward in the legislation with a designated agent, which would be the Harry Fox Agency, that could handle all of the online rights. It was a step in the right direction. But when you do that and you have an agency that is not representing all of the rights, there were questions with administration. So I don't know the solution. What I do know is that we are losing the battle with free and people thinking that music should be free, and that if in fact we care about music and we care about composers and songwriters and music publishers, we have to have an efficient licensing system. And personally, I would love to do away with the compulsory license, but in order to do that, you really have to have a system that works. And that means a collective licensing organization that can handle everything, or an aggregator that can handle everything, but you've got to have a system that works. If you don't have a system that works, then licenses cannot be granted, then legitimate services cannot use that music, but everybody else can get it for free on some website. So with that, I will say it's an interesting challenge in the United States. It may be a little bit unique to other countries in the world, but the issue of efficient licensing is an issue for all of us.
Thank you very much, and thank you for laying the ground for the discussions here, and as usual showing the very typical thing of the United States. As soon as you start looking at a simple problem in detail, it turns out to be pretty complicated. That's something that the US, by the way, has in common with Europe. Laurie Hughes, you can tell us a little about the user's view on these things, and particularly from the digital environment.
I sort of feel like I'm speaking on behalf of all users here, so thank you very much for, as a token user, thank you for allowing me to be here. But I'm really not. I have in addition to similar concerns with all the other digital users, we have, my business is and I'm also speaking on behalf of MUSAC, a large background music company, and EPAS, our competitor. We're all business-to-business providers, and we have certain differences with the other. My background actually is in performing rights. I was for many years both at ASCAP and at SESAC, so I do come out of the collective rights licensing world. And I have for 4 years now been dealing with labels, publishers, and the various collecting societies. So having come out of the collective societies, I thought, well, licensing is going to be pretty easy. We make, TouchTunes, MUSAC, and EPAS make music available in different ways and for different purposes. But our business, our customers are, our direct customers are other businesses rather than consumers. We have a digital downloading jukebox, the kind of jukebox that you find in any bar or restaurant that still has them. You put money in it and you play the music. Our jukeboxes have about 100,000 songs on them, about 30,000 all over the country. EPAS has from the publishers, and a performance rights license, because in the United States, I'm not sure if it, and jukebox operator, rather than the individual location, has to have the license to perform the music in a public place. We don't qualify for Section 115, which would make our life a lot easier, because Section 115 covers only mechanical licenses or reproduction whose primary purpose is for private use, and obviously that doesn't work for us. We also don't string, so we don't qualify for sound exchange, which means the licensing is a little more complicated going to a few agencies. First of all, record labels, it's still relatively simple with record labels, except of course for dealing with record labels. But yes, yes. But I mean, in my world, I love record labels. There's one license from one label, and it typically covers everything on that, all the songs on that record label. And the smaller labels in a marketplace have conveniently organized themselves into kinds of aggregate labels. So now I have 4 licenses with 4 companies that cover thousands and thousands of recordings, and 4 licenses with 4 big companies that cover thousands and thousands, and a few more, quite a few more with others, but it's still manageable. That's the first time anybody ever said that about dealing with the record label clients. Okay. Yeah. Performing rights organizations are also easy because we have 3 licenses, 3 reports, 3 payments, nothing else to worry about. We provide them title, writer, publisher, percentage, when we have the right percentage. We provide the percentage, not always right. And they match it to their records and distribute according to their systems. We can and do track every song played on every one of our jukeboxes, both ECAS and TouchTunes, and MUSAC reports a substantial amount of it. And just to give you an idea, we had 135 million songs played between July 1 and September 30th, so it's a growing source of revenue for everybody. Canada was also relatively simple. It started that way, and it got more. Organizations keep coming out of the woodwork, so I'm not quite sure what's going on there. But we do have CMRRA and SODRAC licenses covering our English and French reproduction rights for the publishers. We have SOPROC and ABLA covering English and French reproduction for the labels. We have a SOCAN license. We have, I need to correct my written materials. It said we have a license with the Neighboring Rights Coalition. We're talking with them. We'll have one shortly. I just haven't signed it yet. So we moved from what I thought it'd be easy, 3 organizations, and it's turned into 5, but still manageable. There are some significant gaps, and when you know it, most of those are U.S. publishers who won't grant CMRRA rights. But look forward to exploring the overall licensing that was discussed by Laurie yesterday. We just concluded agreements in Mexico, and there we had to deal only with SAC and SESAC. 2 agencies, which is wonderful, but you know, that's good. Then there are U.S. requirements. We have, I don't even know the exact number, but well over 1,000 individual licenses covering even more thousand, probably 20,000 or so individual catalogs. When we started in 1998, Harry Fox didn't talk to us. It's an interesting series of correspondence. I'm looking at Charlie, but so ultimately we had to go down the individual license path. We now add info in our database to about 5,000 songs a month. That's again title, label, artist, that sort of stuff. And it results in about 20 to 50 new publishers every week that we have to contact. And UCAS and MUSAC have the same problems. That snowballs. I mean, 20 to 50 is a lot to keep up with in any one week, but next week I've got another 20 or 50, so the backlog keeps getting higher. Make it even more complicated, the same album that we needed one license for may have 10 or 12 songs. And particularly if it comes out of Nashville or even out of the hip-hop world, you got 10 or 12 songs. They all have different publishers because they all have different songwriters. Multiple publishers on the same song, tons of songwriters. The record so far is 27 music publishers on one single song. 27. Grills? Oh, great. I can't wait. So, there is, as we all know, no central database. There's ASCAP, there's BMI, there's SESAC, there's Harry Fox. So you got to check them all to figure out where the song might be, if you're lucky enough it's there. there are multiple incomplete databases because publishers don't register songs until after they know they've been recording, and half the time they don't find out until after the record is out. And quite frankly, for I believe competitive reasons, the databases are not designed to be easily navigated or manipulable. And I understand that. It made a lot of sense to me when I was at ASCAP. So, and when I was trying to license businesses, but it does make it more difficult when you're trying to do mechanical licensing. So, these 20 or 50 publishers that we're tracking down every week, 8, 20, 50, whatever the number is, varies from week to week. If it's a real publisher, by which I mean a real professional publisher who's in the music publishing business, they really don't have time to deal with the volume of requests, the negotiation of licenses, the royalty processing and payments for hundreds of services. And if it's not a real publisher, and a lot of times we get publishers that are post office boxes someplace. Might have been the pizza or other kind of delivery person that was in the studio that day. And try and find it. You're never going to find it. The producers don't know where they are. The record companies don't know where they are. The other publishers are in the same position you are. So it's a nightmare. I think another challenge that we are running into is until there is that principle that theoretically if you own a copyright or an interest in the mechanical share of a copyright, you can license on behalf of all your owners, so long as you account to them and don't dilute the value of the copyright or something like that. Well, that's eroded a lot in the last few, so it was but that's eroded a lot in the last few years because contractually a lot of publishers can't license on behalf of their co-publishers. And as a matter of courtesy, a lot of publishers won't license on behalf of their publishers. But it makes it more difficult for the user to try and do the right thing. And also, as I just said, some publishers don't even know who their co-publishers are. They're afraid of the same liabilities that we face. We think collective or designated agencies are a great idea. I think all of the music users find that a wonderful thing. And we've actually, our little group has been going around and talking to both large and small publishers, a lot of small publishers here in Nashville, the Songwriters Guild, a lot of major publishers, and it's going fairly well. I mean, they're I guess their concerns with the collective agency would be the competitive instincts between publisher administrators who are afraid of getting cut out of the process. Publishers have a desire to control the use of the work, so they're not real thrilled with extending. Some are, some don't care, some are concerned about extending, taking away even any more of their control. And there's also a concern that if an agency is controlled or practically controlled by the major publishers, since they're also owned by the major labels, there's a lot of concern about self-dealing and toxic issues. The way we currently license now, our licenses are basically on a blanket basis, just like our ASCAP and SESAC licenses, our publisher and label licenses give us the right to any of the songs. And that makes it a lot better. We don't have to do a separate email, a separate piece of paper, a separate anything with any song that we do. We do report and pay on everyone, and we report ISRC codes, I believe. So you know what's getting used, but it's not like everybody has to go through another administrative thing. And of course, there's the legal risk. Just to go back to business or B2B specific, we're living in an iPod world these days, and consumers want what they want, and they want it now. So do the consumers who put music in boxes or go to a business location where music is. They even actually pay to listen to music, and they just don't understand why the music's not on the radio. They hear it on the radio. They bought it in the store that day. Our competition, as I said, is CDs, terrestrial radio, satellite radio, iPods, and MP3s, and even pirate jukeboxes. It's really easy to copy a bunch of music on a hard drive, rip out the CD mechanism of the jukebox, and stick it in the hard drive, and not play it anybody. We want to do the right thing. We just need to find a way to do it as simply as possible. And when you think about it, iPods are nothing more than a mini jukebox. People plug them into our sound system, and if we don't have the rights to Bruce Springsteen or Radiohead or Jimmy Buffett, if we don't have the rights to them, they're going to simply plug their iPod into our sound system, play the exact same that recording, and nobody's going to get paid for that either. Then one of the interesting things I heard yesterday from John, and I need to ask him more about it, but the labels are now providing this music service, high-end hotels. And it makes me wonder, I know that it seems to be covered under the sound exchange, obviously, but what sort of mechanical licenses do they have in place? Are they relying on the Section 150 licenses? If so, well then there may be a problem. Because if that's the case, then we should be able to do the same thing. I don't know. They might have actually gone out and done something. Going back to the issue of publisher control, one of the things we hear from publishers is, well, I'm afraid of expanding the scope of the compulsory license or the statutory license because I want to control what's used. And I understand that. They want to make sure it doesn't go to karaoke, which they may or may not want, or include a video or some other use. And I imagine the ringtone issue is part of that. But for us, we're taking the exact same recording that they already licensed, and that is available for physical or digital sale. Can already be played on the radio or the internet. I can bring it in and play it on my iPod. The exact same recording, and just putting it in a different place for play. So I understand the desire for control, but to me this is probably less of an issue. There is definitely less of an issue. And by the way, I already have a performance license to play this song. I just can't put it in the box and play it. So I forget who it was yesterday who came up with this great acronym for BMI, ASCAP, SESAC, BATCH. It was great. So, and that would be this collective body. So I was trying to figure out what it is we wanted. Was there a way to get it? And so I did come up with a few words. It's not as good. I like BASH better, but this will work too. Centralization of licensing, risk reduction or elimination, efficiency, process, simplicity, make it easy. I got efficiency twice.
Only have one E.
Okay. Oh, good. Only one E. And transparency. Make it so we can find the information, and that spells trust. So I guess we can have a trust.
Thank you. That's great.
Thank you very much. Realizing, of course, that there are many stakeholders in this who are also not on the panel. I hope we can stick to about 10 minutes. All of us still, so there will be time for everybody and then people in the audience to comment when we're through the round. So next speaker is Steve Marks.
Well, I'll start picking up on a couple of things, a lot of things that Laurie said, but one funny story about the acronym copyright world that I remember was when the CARP system was created. It was really going to be Copyright Royalty Arbitration Panel. And once people started, as they do in Washington, shortening it to the acronym, it got changed to Copyright Arbitration Royalty Panel.
At the cost of accuracy.
Yeah, at the cost of accuracy. One other little inside RIAA humor, which sounds like an oxymoron, but a story that I'll tell following up on the comment about dealing with record companies. So on a recent conference call that we had with our companies talking about how to resolve one of the litigations we had against an individual defendant who had been sharing on a P2P system, somebody on the call said, I'll just do anything so long as we don't have to have one of these calls. Somebody else said, well, maybe we should have the defendant have to participate in the call. But the consensus was that would have violated the Eighth Amendment, cruel and unusual punishment. So now to the topic at hand. Really from our perspective, a lot of the things that Mary Beth and Laurie have already talked about really apply to us in terms of the need for a better system for 115. I don't think there's much debate about the fact that the system is broken. And from our perspective, there really are two kind of overarching principles One is being able to meet consumer demand and in order to provide compelling services in what we know is a very fast, ever-changing world that we're living in terms of new business models that are launched, it seems like every week. And to have a system that responds to the needs of those that are in the business of launching these systems, so that we can provide the kinds of consumer products or services that we know people are looking for. And if we can't do that, we've just all lost. I mean, there's just no question about it, given the alternatives that we all know that exist in terms of getting music for free. And the other is really the administrative efficiency point. The two kind of go hand in hand. But the first deals a little bit more with the scope of what might be included in a licensing system. And the second deals with more the process of the licensing system. And so when we had the discussions last year to reform the Section 115 license, one of the points that we stressed was that what is included in the license today, which is essentially straight audio products, is really not what consumers are demanding in the marketplace right now. And setting aside whether the system should be compulsory or some kind of voluntary system or MRO system that Mary Beth proposed, we really should have a system that includes all the rights that are necessary to provide consumers what they want. And that more and more includes things like video. And if we reform a system and that is the current system, and make the current system more efficient, at the end of the day, we really haven't solved very many problems, because those aren't the products necessarily that we need to deliver to consumers to have a vibrant recording music business. And so it's very important to us to find a way to have some kind of system that's easier than the current system to address the kinds of things that consumers are demanding. Secondly, in terms of administrative efficiency, we had some examples, in terms of the splits. One of the ones that we showed, Chairman Lamar Smith, who was leading the process at the time, was what it took to clear the recent Jennifer Lopez album. How many actual licenses were needed, mechanical licenses, and it was something like 225 by the time you got through with each song, all the other composers and publishers, all the different configurations. Just because you got a license for the physical release, you still had to go then get a separate license for the DPD release to demonstrate what was involved. And if you just think about the overhead that is involved at a record company or any other company that has to clear the licenses in order to do it, it's it's a full employment act, I guess, for people who've got certain administrative skills that can do this. But on the other hand, for efficient businesses and having businesses that can be profitable and get things to market, it just simply doesn't work the way it is today. So we talked a lot. There are a lot of issues kind of in the weeds that I'll just mention that haven't already been mentioned. One thing that's a big issue for reforming 115 is the first use requirement. If you have a new system that's improved and you're still required to get the first use license, which, by the way, is a very difficult thing to get if you don't have the rights to a controlled composition clause, for example, because you have these fights about what the splits are and who owns it and who's going to get a piece of the mechanical, etc. You really haven't improved the system very much, because that all of the effort that goes into clearing that first license still exists. And so, and the same kind of thing really goes for samples. In the hip hop world, 30 to 40% or more of the songs have samples in them, and to be able to get those cleared, understand who's going to get paid for them, what part of, usually what happens is the owner of the work that's being sampled or that's included in the song will say, fine, I just want a piece of the copyright. Well, then the question is, well, how much of the piece? And if they take half of the mechanical, how do you divvy up the other half? The other half is among the composers and publishers there. So, there are a lot of issues like that that need to be part of a global fix. The easiest system, frankly, would be to have one collective. I mean, it's really the sound exchange model. You have a single collective where you have a blanket license system. You take the license, you know you're licensed, and then all of the work in terms of determining, who gets paid what pursuant to splits and based on how many songs have been distributed and etc. All that reconciliation is done down the road, but you enable things to get to market and the services to be able to be launched. That's the kind of system that we really need. Having redundant databases where you have individual record companies, individual digital service providers, the publishers themselves, or some kind of multitude of designated agents is just unbelievably inefficient. To have everybody recreating all these separate databases in order to do it. A central database at one collecting agency where that collecting agency is responsible for ensuring that the money that should be paid in a timely way gets to the royalty recipients is really the best model for a system. And the question is whether you do that under a compulsory system or some kind of voluntary system. Obviously record companies, we're not fans of compulsory licenses, and so it's often pointed out to us, well, when it's your own rights, you certainly don't want them, but when it's somebody else's, you're happy to take advantage of it. Truth is that we would be happy moving to a voluntary system and one that worked. We're not sure that this time right now is the best time to do that, given what's going on in the industry and the upheaval, but over time, moving to a system like that, the PRO system works very well on the performance side, is not something that we object to. So it's really about getting it right in terms of the administration and the efficiency, and in terms of the scope of the rights that are offered. That's important. There were some other things that were part of last year's bill that I think are essential going forward. For example, there was an interim rate proceeding option, so that if you have, one thing that we often encounter is somebody comes up with a new use, and it doesn't really fit neatly within the prevailing rates under the compulsory license. It's not a pure download, or it's not what we know today as a tethered download. It's some kind of hybrid of a digital and a physical product or something like that. And there's really no mechanism under current law to have a rate set for that until the next rate proceeding. And so you have this tremendous uncertainty about what the rates are, which makes it very difficult to launch the new models, because when you've got different partners that you have to have business relationships with, you need to have that kind of information. So one of the things that was included was an interim rate process, which we thought was was very good. The direct licensing issue is an interesting issue. From our perspective, we want record companies today generally sublicense rights and clear rights for the digital services. They rely on record companies to do that for them. If a digital service provider wanted to do that themselves, that's something that's fine. Our position last year was that there should be an option, though, at least, that if the digital service provider didn't want to create that entire infrastructure and hire all the employees that are necessary to do that clearance, and had the option of relying on the record companies to do it, who are clearing licenses anyway for physical release, then that option at least should be made available. So we weren't opposed to direct licensing. We were really just looking for an option to preserve sub-licensing where the distribution company is desires it. Another big issue that came up last time, just briefly, was control compositions, and the only thing I'll say on that is moving to a percentage rate, which is an issue that kind of straddles both the administration issues and the rate issues, which we haven't talked about, is something that could be explored to deal with the control composition issues. But we can talk more about that and other things later. I'll leave it there for now.
Very much.
I'm going to be pretty brief, as I usually try to be. I am truly sorry that Rick is not here today. And he sends his regrets. He's very sorry that he couldn't be here today, too, because it's extremely important at gatherings like this. Not hear from talking head attorneys like my colleagues, but you hear from creators.
Speak for yourself.
I thought I'd speak for both of us. All right, he wants to speak for himself. There are there is at least one master songwriter in this room right now. Voice is sitting over there. Come on, give it up. Who wrote, among other hits, Hit Me With Your Best Shot, and other stuff that you know by heart. And I'm going to be brief so that in case he wants to add anything at this time, later we can do it. I started out as a studio musician. Damn hard. It was too hard to make a living. Being a creator is so much more difficult than people who haven't done it give credit. It's an astonishing thing that you actually sit down and get to spend your career with people who try to make a living creating things out of their gray matter and out of their talent, and you actually learn the kind of suffering, not necessarily living in an artist's garret somewhere, but the kind of internal struggle and financial struggle that these people go through to do what they feel they must do, to fulfill the destiny of their happiness or whatever it is. But there is a group of people in this world called creators who do that. And my job is to protect those people as best I can. And I think perhaps all of our jobs, no matter which side of this argument we're on, is to protect those people and make sure they can keep creating, because they make our lives a lot richer and a lot better. And I think that anybody who's been involved in the music industry for as long as all of us have starts out the day basically saying every morning, geez, I'm glad I get to do this for a living. I still do that every day. These are the people we need to protect, because if I was a songwriter, I could sit here and say, I am the bedrock of this industry. If I don't get up in the morning and have an opportunity to write, we can all go home, because there's nothing to do. Our livings are based on the abilities of these people to continue doing it. We must protect that right. Now, how we do that, of course, is the matter that we spend most of our time debating. When David and Stephen and Laurie and I used to get together when we were kids starting out, and we all started at the same time, we would actually be talking about music. Now what we talk about is this stuff. And I'll tell you what, it gets annoying after a while. It truly does. We're here for the music. So I think it's really important to view everything that we're talking about within that framework. We tend to forget it. We tend to see as though we're speaking about products like shoes and cars. We're not. We're talking about creative product. We're talking about intellectual property that people sit and spend years trying to create. My wife included, who after 25 or 30 years in the business, finally, has broken through. And it's a pleasure to see, but it's also it chagrins me to know how many people who were equally talented and simply did not have the resources to continue in their field. We lost creative pride. I will only say on the topic of what we're talking about today, very briefly, that we need to do the mechanical license and the compulsory license in its historical context as well. And that is when we talk about, well, should you go to a free market, non-compulsory playing field, which suggested several times in the past. I mean, I can remember 15 years ago when I was in Harry Fox and NMPA discussing this at length. We have to view this in the context of, okay, as Mary Beth suggested, in 1909 we had a compulsory license. And the compulsory rate for mechanical uses of music on phono records was set at 2 cents. And we imposed basically a wage and price socialism scheme on this area of the music business that provided for 70 years, 7 decades, a price fixed on mechanical records. I mean, I defy anyone here to name me another industry that has been subject to that. 2 cents in 1909, 2 cents in 1977. It's astonishing. The day that the mechanical rate went up in 1978, one of the RIAA client companies introduced in earnest a thing called the controlled composition clause, imposing a 75% rate on a rate that had finally gone from 2 cents to 2 3/4. You do the math, they put it back down to 2 cents immediately. And the last 30 years we have tried desperately, in negotiation after negotiation in which many of us have participated, to somehow try to get the playing field from being this to kind of being like this. At this stage, when we talk about can we remove the mechanical compulsory license without tagging it to some basic minimum, can we look at each other with a straight face and say, well, what we've got now is a level playing field? I don't think that it's possible to do that right now. Unfortunately, and again, Steve is a good buddy of mine, and I am not taking RIAA to task. I'm talking about your client companies. The songwriters work hand in hand with the rest of the music industry, including the recording companies, and we have many mutual beneficial interests that we share. But for Steve's client companies to come in arguing for a new mechanical rate and to ask for a 50% reduction, I have no comment that is printable in a newspaper about that. After 70 years at 2 cents. So we're going to have to figure out a way in closing now to make sure that we keep in mind that the people who need to feed their families and send their kids to school and buy groceries and other necessities need to be compensated. This is the human face of the music industry. This is the only face of the music industry, because without them, we're all going to die. So if we don't take that seriously, we're in even deeper trouble than the shambles that we're looking at right now.
Thank you very much. And last panelist, Mr. David Baskin. But then, while you are setting up, then since several of the speakers in the panel have pointed a little about the practicalities that would be involved if you would have nobody use the word non-stop shop, but sort of one single organization to get to. In the case you invented such a thing, wouldn't you have immediately, for antitrust reasons, to split it up again?
No, I don't think you would have to split it up again. You may be subject to oversight, well, you would be subject to oversight by the Justice Department, just as ASCAP and BMI do now. But I have to say, I'll be honest, when I proposed a music rights organization and we thought it was a great thing, the Justice Department lawyers came in to us and said, that's a terrible idea. But that didn't deter us. I think the issue is whether you do it under a compulsory license or collective or a combination of the two. But we got to get there. I just want to say one thing on behalf of Rick Carnes, who isn't here, and Charlie was speaking on behalf of. Rick Carnes goes around, and I've been on many panels with him, saying, I have to eat if I'm going to write. And his one thing that I find actually very disturbing is he says we have to keep the compulsory license because that's the only way that songwriters can get a fair deal. That we have no bargaining power in the marketplace. So unless we have an established rate where somebody other than the businesses are setting the rate, we will never be treated fairly. And that's a pathetic statement, but maybe it's true.
Thank you. We can continue discussions about that. I'll invite the panelists to go to the first row so we are not getting the PowerPoint right in our face.
And it's like, because I'm bringing like a Canadian computer, eh? So it's got to translate out the words and like change out the spelling. All right, thank you very much. We don't actually talk like this. Well, thank you very much, and I first of all want to thank the organizers of the conference for adding me to the agenda at a late date. It's very much appreciated. I'm going to make a presentation of a couple of things, but I mostly want to talk about how we address the question of licensing the reproduction of songs and musical works in the online environment in Canada. And for a long time, we have resisted using the term mechanical licensing because that would sort of imply that there was an equivalence economically between the traditional mechanical licenses and the online environment, but that's not such a relevant point anymore. So you see the title is No Compulsion. And I want to talk about how you do it in the absence of a compulsory license. So the following chart illustrates the current state of the music industry. And it is, of course, against this context that so many of our discussions take place. In Canada, the Copyright Act, which has its origins in 1911 UK legislation, was first passed in 1924 by Parliament, established that there is a reproduction right in musical works. It's exclusive to the owner of copyright. It includes the right to authorize the reproduction of works. There is no mechanical right per se in our Copyright Act. Mechanical licensing or the licensing of songs for reproduction on sound carriers is simply an aspect of the reproduction right. The 1924 Act established a statutory compulsory license of 2 cents per playing surface, and Charlie, I'll do you one better. That was in place for 64 years until Parliament wisely eliminated it in 1988. The music industry in Canada grew very slowly, and it wasn't really till the introduction of content requirements, Canadian content requirements on radio and television in the 1960s that there was a real growth of the music industry. And with the growth of the music industry, there was a demand for licensing services that was very welcome. So before 1988, the mechanical license was set at 2 cents. The end of the statutory license opened the door up for publishers to negotiate directly with the Canadian Recording Industry Association, or CRIA, which is the equivalent of the RIAA in the United States. Here I'm talking about negotiations that were carried on by CMRRA, but in a moment I'll begin talking about CSI, and I'll explain the transition in a moment. The result for CMRA was the negotiation of an overall document, a general agreement called the Mechanical Licensing Agreement, or MLA. And it established a royalty rate, a single royalty rate applied across the board. But as Charlie just outlined, the pernicious and tumor-like effects of the controlled composition clause on the economic value of songs had to be addressed. After all, there was little point in our increasing the value of the standard rate in the agreement, only to find record companies turning around and unwinding that by successively amending their controlled composition clauses. For those of you who aren't familiar with it, a controlled composition clause is a portion of an agreement between the performing artist and the record company, where in effect the recording artist says, in return for the record company granting me a deal, I will give the record company a reduced rate on the reproduction of my songs. The trouble is that it devalues on a wholesale basis the value of songs in the marketplace. Now, sadly, these are legal, but their economic impact is quite substantial. So what our agreement did was to say to the record labels, in return for a royalty rate you can live with, you're going to accept some pretty stringent limitations on the use of these clauses. Now, I don't have time today to go into it, but the net result is a significant increase in the royalties that would be payable had there been no controlled composition clause. So that's why in the past 20 years or 15 or so years, our royalty rate has appeared to be lower than that of the United States, but in fact it's probably pretty close to parity when you factor in the impact of controlled composition clauses in the US versus their limited impact in Canada. That's not really the subject of my talk, but as you'll see, the question of the impact of controlled comp clauses in the physical goods environment did become part of the discussion in the online licensing case. The online music market in Canada was slow to start. Companies tended to establish themselves in the US, well, the largest market, largest possibility for return. Canadians have been very, very enthusiastic consumers of high-speed broadband internet access, whether by cable or by telephone line or satellite. They just love it. Canadians have always been very swift on the uptake of new communications technologies. As a result, our morality is no different than that of anybody anywhere else in the world on a collective basis. P2P file trading, I won't say sharing because I find that prospect repugnant. You can't share that which you do not own. It's trading, not sharing, is at record levels and continues to rise. In the online marketplace, there is no statutory license for the reproduction of songs or master recordings. In fact, the Canadian Copyright Act has very few compulsory licenses, and they certainly don't apply at this point to the music business. So our experience at CMRA was in 2002, we began discussing the prospect of licensing online music delivery services, or DSPs, digital service providers, as they are sometimes called. The record companies were directly involved at the beginning because the two services that we're talking about coming to Canada, PressPlay, which was owned by Sony and Universal, and MusicNet, which was owned by EMI, Warner, BMG, and other investors, they were intimately involved with these services. Now, the position of these online services / record companies was that the online world was exactly equivalent to the physical world. It was another form of retail commerce, which is certainly one point of view. We didn't agree with it. They said that they'd do us a favor and license our songs for online music, and that they were delivering finished goods to the online stores. Again, it's one model, but we happen to disagree with it. We said no, and this kicked off a fight that lasted for 5 years. Simply, we wanted to be maître chez nous, masters of our own house. We wanted to be in charge of our own destiny. We'd had enough experience with record company accounting over the years to know that we could do a better job ourselves. And all kidding aside, you look after your own interests better than somebody else will. The record companies weren't particularly interested in our sub-licensing their master recordings on their behalf. We felt we should each take care of our own interests. So we negotiated at first an OLA, online licensing agreement, and it was a brutally difficult negotiation. In the course of this negotiation, the record companies sold off their interest in online companies so that the online companies were true standalone propositions. Finally, we made an agreement with no royalty rate. We agreed to negotiate, put it to arbitration if that didn't work. The sticking point continued to be who issues the licenses, and the labels finally appeared to give in on this point, but not quite. In October 2003, RIAA was ready to sign, but Sony BMG pulled out at the last minute, claiming that they weren't a party to the agreement. Well, no record company was a party to the agreement, so we ended up signing an agreement, but it was a flawed document. What really was going on is that the people who were working at Sony BMG were violently opposed to the proposition that we should be licensing our songs to online parties, and this fight went on for a long time. In fact, our attempts to negotiate a rate failed. We referred the matter to an arbitrator, which was eventually settled without a real resolution. At this time, Sony BMG was telling online services, you give us the publisher's money or you can't have our recordings. When I went to law school, we called that extortion, but I guess things might have changed in the meantime. Now, the online companies said, we're caught up in your fight. And they were right. They said, look, we just want to do business. We want to sell music online. We want to make a living here. Maybe make some inroads against piracy, which you say you want. So why should we get caught in this fight between you and Sony BMG? Oh, a good question, but there was very little way to resolve it amicably. The label took a very, very strongly held position that they should license our songs whether we liked it or not. Now along comes CSI, which stands for CMRA Sodrac Inc. And our good friends at Sodrac in Montreal, which is headed by my friend Alain Lozon, who's sitting over there. Sodrac is an authors society. CMRA is a licensing agency, and you will all appreciate the difference. We do business on behalf of different rights holders, but with the same goal of licensing the reproduction of our respective repertoires. And CMRA and Sodrac had formed CSI a little earlier for another purpose, for the licensing of the commercial radio tariff, which I don't have time to talk about today. We were founded in 2002. And why did we join up for online licensing? Well, strength in numbers. There's no compulsory license to look at. And we had common objectives. We wanted to do this affordably. We wanted to deliver the largest possible repertoire to users, and that combined repertoire continues to grow. Most of our surveys of repertoire and usage that we get from the online services show numbers well in excess of 80%. I believe that probably within the next 8 or 9 months we will be closing in on 90% representation. So we figured that by working together voluntarily, we could do most of the job and continue to aim towards the 100% target. We'll never hit 100%, but I think we're going to come pretty close. Because when you get right down to it, everything in music business, like most businesses, comes down to a decision of buy or build. Do you buy the service or do you build your own? Most rights holders can't really afford or don't want to afford the difficulty and the complexity of licensing many individual online services, and they're choosing to join up with either CMRA or Sodrac with the goal of licensing their songs and collecting their royalties. So in 2004, we filed a tariff, which is proposed rates in terms of licensing, and the consequence of filing a tariff, or at least of having a tariff certified by the Copyright Board, is effectively you must license everybody who comes forward who is willing to meet its terms, which is fine with us. You don't make any money saying no. We're not here to stop people using. We want to authorize people to use the works legally. Why did we file a tariff? Well, with more online services arriving in the market, it was simply impractical to try to carry on direct negotiations with them. The direct negotiations had not worked. The Copyright Board is a superior forum to decide these very difficult issues like rates, notably because there's a very extensive and powerful pre-hearing disclosure process by which people get to find out the important details, which would otherwise likely be withheld from you in a negotiation. We filed the tariff, as all tariffs have to be filed prior to March 31, applicable for 2005 to 2007. We proposed 3 categories of use: permanent downloads, DPDs, 15% of the retail or 10 cents a song minimum, subscription limited downloads, 10% of the subscription price or $1 a month, and subscription on-demand streams, 7.5% or 75 cents a month. And again, these were all with respect to the reproduction of the music. It did not touch on the right to communicate the work to the public by means of telecommunication. Who else would politicians to come up with a phrase like that, that SOCAN administers? In the meantime, we issued interim licenses on behalf of CSI. We licensed 15 services against the prospect of advances to be paid against the rate ultimately to be fixed by the board. But the fight with Sony BMG continued. They kept on telling online services, you have to pay us the publisher's money or you don't get our recordings. Some online services acquiesced and some didn't. In the pre-hearing process, we exchanged a lot of information under interrogatories. Most of the really good stuff was sensitive confidential, which means that I didn't get to see it, but our lawyers and expert witnesses did. We filed our cases in the summer of 2006, and the hearing was held in September over 10 days. The hearing attracted tremendous interest. The first few days of the hearing were attended by a very large, unusually large number of people. CSI was faced across the table by RIAA, Apple, Napster, and the telcos, the telephone companies who are also in the online music delivery business. And I think everybody was very ably represented. Now, the proxy, what should be the value? We said that the value of the reproduction of music in the online environment should be based on the value of reproduction of music in the ringtone environment, where the board in a previous decision had said that the average open market negotiated rate was 12% of the retail price. Our opponents said that the downloading of music was economically equivalent to CDs, and that the value of songs in the online environment should be equivalent to the CD environment. Ultimately, we said we should be issuing the licenses. Our opponents said that we should be forced to grant licenses to the record companies that they could sub-publish the rights through the labels to the online services. The decision, they set the royalty rate for permanent downloads at 8.8% of retail. And you can see the minima there, 5.9 cents per track when sold individually, 4.5 cents a track when they're sold in a bundle of 13 tracks or more. This information is all in the Copyright Board's decision, which is online on their website. Limited downloads, 5.9% of the subscriber fee with various minima, and on-demand streams, 4.6% of the subscriber fee with a minimum rate of 29.2 cents per sub per month. It's interesting to note there are no services doing business in Canada which are exclusively providing on-demand streams. All the services that provide subscriptions also provide permanent downloads and on-demand streams, in which case they pay the higher rate for the limited download service. The board also ordered that the rates be discounted by 10% for 2007, but most importantly for us, they said that there was no value in the labels issuing licenses for our music. I frankly don't think the board would have had that power, but it's a moot point, they did not make that order. They said that the value proxy was the CD, but in determining that value, they said that the impact of controlled composition clauses, which we talked about earlier, was not to be taken into account. Issues like free goods, other music industry practices were not relevant. And they said that the bundled track minima was based on 13 songs per CD. That's an issue we may come back to. We think the number is actually higher. So the administrative terms, I won't bore you with too many of the details, were the subject of a great deal of discussion in advance. And by the time the decision came out, these complex administrative terms had been already decided much faster than in previous board decisions, which we think is a good breakthrough. I want to talk about one particular issue, and that's the information that must be provided by the online service to the rights organization, the CSI. It's vital that when they tell us what songs they're using, that they tell us not only the name of the song, name of the performer, and various other details, but also the songwriter data. Because without songwriter data, it can be impossible to figure out what song is being used, and thus impossible to know on whose behalf the license is to be issued. As you all know, copyright does not protect titles. So I'll just quote you this paragraph. The board said that if information is essential, a service ought to provide it, even if this means getting it from someone else. Music labels do not always provide online music services the name of the author of a musical work, but this is not reason enough to relieve the service from providing the information. At the moment, it's a best efforts requirement. It will be mandatory after this year. That's a very important breakthrough. Now, the online services may not have the information, but the record companies should have it, and when they provide the masters to the online services, they're going to have to flow that information through. Historically, record companies, some have done a good job, some have not done a good job about keeping track of it. We know from the mechanical licensing side that the record companies frequently do not identify vital information, and that makes licensing less efficient than it should be. And as you all heard yesterday, the board issued its decision with regard to SOCAN's communication right. The basic point is the board has set the value, the combined value of the rights in all these environments at 12.2%. We're thrilled to say that it looks like to be the highest cumulative rate in the world, which is a good thing. I want to talk about, and I know I'm running long here, but I just want to show you something, because Jim Griffin, from whom all wisdom flows, said something yesterday about the increasing blurring of the line between downloads and streaming. And as I was sitting there wondering about this, I downloaded a free piece of software for my Mac called TouchTunes. And this is typical of some of the things we're seeing. TouchTunes runs on your computer, turns your computer into a file server, and allows your computer to become a file server essentially to the whole world, with or without passwords, with or without user controls. I won't bother hooking it up now, but I've got 3 albums in there: the Arcade Fire album, Neon Bible, Fiona Apple's album, Extraordinary Machine, and Julie Black's new release, Revival. I'm looking at these through a web browser, and I can in fact listen to them on demand. So I've turned my personal collection of files into a streaming service. And if I gave you the URL anywhere in the world, you could be listening to streamed files off my computer. I could set up a password, user ID password criterion, or have none. Now, This certainly isn't licensed. I didn't get a license to run a streaming service. I'd have to sit down and figure out whether or not the very existence of this infringes something. Probably does. I mean, the basic proposition is I should be getting money, right? The reality is that technology is moving so fast that even this software, if you had a chance to look at the neat little iPod Touch, the latest version of the iPod that has Wi-Fi in it. This is not an iPhone. It's like an iPhone without the telephone. But this device has Wi-Fi in it and a web browser, and that means walking out anywhere where I can get Wi-Fi, like this room, I can stream the songs from the computer directly to my iTouch, not have to buy any songs. So as fast as we're trying to address these issues, and address the extraordinarily complex issues that have already been discussed on this panel of how do you identify the songs, how do you license them, how do you actually get from point A to point B, it's like trying to herd cats, like trying to nail down Jell-O, choose your cliche, but this is what we're facing. We're facing, whether it's your BlackBerry or your portable music listening device, the combination of wireless technology with amazing data storage technologies are pushing the music onto every possible device. One solution to everything? Listen, I'd be happy to come up with one solution to anything rather than one solution for anything. You know, we're taking all good suggestions, you know, on demand. Anyway, you've been very patient. Thank you very much, and I welcome your questions.
Thank you very much. It's sometimes a very unpleasant task to be moderator and have to sit and wave such a sign in front of an interesting presentation. So, I'm pleased to open the floor for questions and or comments. We have young people ready to bring out the microphones. Yes, please, sir. Please wait for the microphone, and please identify yourselves. The gentleman up there in the middle, the white shirt. Please identify yourself, because for the compendium you would otherwise be an anonymous voice from the auditorium.
I'm Neville Johnson. I'm a lawyer, and I represent owners of rights and artists as well. I'm just curious. We've heard a lot of talk about how bad it is in terms of free sharing. Is there a statistic that is actually available now? Is it 60% or 96%?
Well, I'll tell you what we do know, at least based on our survey, and it's not exactly what you asked, but I'll give you the information. Last year, we found, according to surveys that we did, that basically, in terms of music acquisition, that 51% of music was acquired illegally and 49% legally. And it was the first time we had seen the crossover, so that you basically had more music being acquired illegally than legally. Within that illegal bucket, you had online piracy, P2P and other, and burning discs and distributing them to friends. So it was a combination of the two. So it's a very troubling, on the one hand, what we're seeing is that the consumption of music is growing. And there's no question but that people still love and want music. The acquisition of it, unfortunately, is more and more illegal than legal.
I've seen statistics.
Microphone, please.
I've seen statistics that much higher, up above 90%. And I mean, so if you want to know about what the statistics are in Mexico for sale of physical product, that's over 90%. So I mean, it's not unusual to have numbers like that. I just, in my gut and anecdotally speaking to students constantly in Greenwich Village, they don't buy music anymore. They take it all. I mean, the piracy rate amongst the students that I deal with is 100.
The communists.
They're dot communists.
Thank you very much.
Yes.
Mario Bouchard, General Counsel, Copyright Board. Just one point that I wanted to add on David Baskin's presentation. He was talking about the issue of sub-licensing through the labels. The tariff goes a little bit further than what he described. The tariff actually provides that the labels are not authorized to avail themselves of the license, even if they were legally entitled to act as sub-licensees. And we added that if they tried to circumvene those provisions, we would make the administrative provisions of the next tariff so unlivable for them that they never want to be sub-licensees.
That clarification. Yes.
Well, my name's Ken Sandy. I'm an attorney here in Nashville, and I teach copyright law at Middle Tennessee State University in the recording industry program. This question is for Steve Marks. Regarding Jim Griffin's lecture yesterday concerning the difference between products and services, I know the recording industry is spending a lot of time doing lawsuits, using the legal system as far as the services, as far as the product goes. What is it doing to move more towards a service model?
I'm not sure I understand the question completely. You're saying that our piracy is directed only to...
No, I'm saying that you're, the legal actions that's been filed by the recording industry is going after people more on a product model, the business model of music as a product. And I was wondering what the Recording Industry Association is doing to move more towards a service model.
What do you mean by actions that are more like a product? I mean, we file lawsuits against either online services that are unlicensed and whether they're P2P or other services. And unfortunately, we've had to also file lawsuits against individuals for using those services. And the goal of all of that is to move people to legal models, whether it's buying something in the store or something online, and whether it be a subscription service or a download service or whatever it is. So, I mean, we don't have a specific objective of moving people to one kind of product or service. It's really just a legal versus illegal.
I understand. I guess what I'm referring to is I don't know if you were here yesterday when we had that discussion. Oh, okay. There was some discussion yesterday about moving the music industry from viewing music as a product to viewing music more as a service because of the ability to stream online, the ability to do those types of things, and the Recording Industry Association's lawsuits were kind of used as an example of looking at music as a product instead of a service. And I was wondering if the recording industry is starting to move more towards looking at music as a service instead of a product.
Yeah, I mean, I think the answer is yes, and they've been doing it for some time. I mean, you talk to any record company, and they're basically licensing every possible, service or product-based business that people are proposing to them. So, subscription services are services that have been up and going for a long time now that have been licensed. But other types of services, the record companies, I mean, they basically license virtually everything that's proposed to them in the hopes that, one or more of these are going to take off as something that will be compelling to consumers.
Not to be contrarian, but I think that's a lie. If you're talking about saying to people coming to you for licenses, sure we'll license, but you got to pay us X amount of dollars up front, which is an astronomical figure. And I mean, and this is their right to do, but they are closing the door to many licensing opportunities by setting the bar that high in terms of guarantees. And I think also the fact that, again, as the point that I made from the audience yesterday, when we are 12 to 15 years down the line from the first inklings of what was going to be happening in terms of piracy, and we still do not have a site that people can go to where they can get all the sound recordings that they want in a single place. To me, and speaking personally and on behalf of no organization, this is an act of insanity. You couldn't design a system to cause the breakdown of an industry better than that one.
Let's talk about what's actually happening in the licensing space, because I think this is a nice little diversionary tactic from what we've been talking about here, which is that the system that's really broken is on the publishing side. It may be the case that look, there are licenses being issued by record companies to all kinds of different services. The fact that they can't make a business some of them can't make a business in the real world is just a reflection of the fact that you have a new kind of business model where there are a number of startups. Not every startup makes it, and you have them competing in an environment where you've got a tremendous amount of piracy that the record companies are bearing the burden of fighting, and not the others in the industry. But let's talk about some of the things that have interfered with getting things out to market. For example, a multi-session disc. When there were multi-session discs that people wanted to release a few years ago, so that you had different sessions for different kinds of products that people, or different kinds of devices that you could use anywhere else. What did the publisher say? They said, "Oh, you owe us a mechanical for every single one of the sessions," even though it was the same exact thing that couldn't be listened to, more than one time at all. So you had to pay 5 mechanicals for a disc that just allowed the consumers to be able to do it. That stopped the market. I hear from labels all the time that they have ideas and they go to the publisher about, we need to do this kind of promotion, or we've got something that very timely, we can do an exclusive with Best Buy to get a certain thing out in the marketplace. And by the time they hear back from the publisher, they've lost the opportunity completely to be able to do the exclusive. So
I'm not hearing this.
Excuse me, I think I'll try and keep a little bit in order. Maribeth, did you ask to?
No, my only comment was, I think when you sue for infringement, you're always going to sue on a work. And so the product and the service really goes to the way that it's licensed. But when there's an infringement, whether the infringement takes place from a service or whether it takes place from a physical product, at the end of the day, there is a song and there's a sound recording, and it's a single thing.
I guess my comment on that when I was asking the questions, it seems to be what's in the media the most right now about the Recording Industry Association of America's efforts at compensating their clients and clientele has been these lawsuits. I mean, that's what's getting the media attention. I just wanted him to discuss some other things they're doing, more looking at the service instead of the product.
Yeah, well, the lawsuits are not intended to compensate in terms of actually getting money into the hands it's to stop them. It's a deterrence policy. We lose money on the lawsuits that we bring, especially against individuals. So it's a money-losing proposition, but we feel like it's an investment that the industry has to make, just like the investments that most record companies have made in completely creating new infrastructures and new departments to be able to work with mobile services and other kinds of companies to license their products, which they have done. So.
If I could just offer the possibility of a breakout of rationality, there's, or perhaps pacifism, who knows? Record companies and publishers have been at each other's throats for the last 5 years over this issue, and the great virtue of the Copyright Board's decision is that it has settled a lot of questions. We would have loved to have gotten a higher rate, and I'm sure the record labels would have loved to have been able to take our rates, do our licensing for us. The reality is we're in the same business, and we always have been. And when no one's selling anything, when all the works are being stolen, none of us are getting paid. And very interestingly, in the past couple of days, I found out that one of the major labels would like us to go in with them to go visit an interesting U.S. online music service that is not yet decided about whether it wants to open up in Canada. We'd love them to because we'd like them to grow the market. And so the label said, would you come with us and talk to these guys and tell them that the way is open for this to happen? We're delighted to do that. We see nothing to gain in this endless fight. We're both up against a market that has too many thieves in it. So, one of these days we might all turn around and say, if we turn around and stop beating the living daylights out of each other, maybe we could do some business here.
Charlie Sanders.
I just want to quickly clarify two points. First of all, that was not an accusation that Steve was lying, but rather an accusation that his clients were lying, or he's not giving him
Too late, I took it the other way.
that he wasn't getting
I'll take it
the
back
straight
now.
dough. The other thing is, if we're going to sit around, one sentence, if we're going to sit around and talk about eliminating compulsory licenses as a possibility, we also have to sit around and talk about the possibility of having two compulsory licenses, one for the publishing right and one for the master right.
Yeah, Laurie, and then I would say, just in order of fairness, if there should be a music publisher who wants to have a word at this point, then that would be the next person. Laurie?
And I just wanted to add to Charlie's point, trying to enter the market, I think a lot of people don't know whether a new service will work, and the reason, part of the barrier to the entry is the advances that Charlie was talking about. If you have to have millions of dollars up front to deal with each individual record label, you're never going to know. I mean, it eliminates so many people being able to go out and actually try and see if it works.
Thank you. The gentleman there. Please remember to identify yourself.
I'm Duff Birschbach from Sony ATV Music Publishing in-house counsel. So I guess one thing I'll say as far as the publishers are the problem is that we work in good faith as hard as we can to try to license these things, and as this conference has shown, it's not that simple. And do we do direct licenses for performance, and when the PROs can really do it best and have done it best, but there are lots of different things, so it's not as simple as saying, hey, the publishers are the ones holding things up. I do want to ask one question, though, to David, I guess to Stephen as well, and that is, in Canada, you've got a private copying levy, and we have a similar thing here, but on a very narrow basis for certain very narrow blank media and devices, recording devices. There's a lawsuit going on right now with XM and one of its recording devices. And my question to Stephen is, in the context of that litigation, or more broadly with legislation, has there been any suggestion made by the labels, and I can't speak for the publishers or Sony on this point, has there been any suggestion that we'll settle this litigation and give us a couple of pennies on regular CDs and a couple more than a couple pennies on your devices, and we create the pool of money, and we'll find a fair way to split it up, and that at least solves one part of the issue with respect to the consumer electronics manufacturers and their products. So, I mean, we've got this system in place with ARC and the HARA, but the pool of money is not that big because it doesn't apply to that much. So could we possibly expand that and solve one part of this issue that way?
I can describe what goes on very briefly. In Canada, there is an exemption so that private copying for personal use is not an infringement of copyright. In return for the creation of that exemption, Parliament created a levy, or the entitlement to collect a levy for the benefit of authors, music publishers, and qualifying performers and makers of recordings. We collect a levy presently of 29 cents on every audio cassette, 21 cents on every blank CD, and there are also collections on other media like mini discs that don't sell very much. We are presently seeking to expand that to include DARs, which is not Daughters of the American Revolution, although a levy would be an interesting proposition. But those are digital audio recorders similar to the iPod. It's not iPod specific. We've proposed a series of rates based on capacity. The board has yet to hold a hearing on the question of quantum, but there was a motion brought by the makers and retailers to say that the application of the statute was improper in the case of DARs, that the DAR was not a medium which was subject to a levy. The board has issued its ruling in which they supported us and said that the device itself, the DAR, is a recording medium as defined in the Act. That is about to go to the Federal Court of Appeal for judicial review, and in a somewhat bizarre turn of events, the record labels have intervened against the rest of the private copying collective, the independent record labels, the performers, the writers and publishers, and they've taken the side of Apple and Walmart and so on. It's a very curious affair. We're confident that the board made the right decision and will move on next April to decide the value. We distribute the proceeds on the basis of airplay and sales data to writers, publishers. We've distributed more than $100 million to more than 90,000 payees, and we think the levy has been a big success. The levy does not authorize P2P file sharing, The levy recognizes the value of the copies that people make for private use, and we think it's been a success.
Well, the XM case is really, XM raised as a defense the HRA, but they're really two different things. What XM is engaged in is essentially a distribution, and that's what we argued, and that's what the court said in rejecting their defense that this was somehow covered by the HRA. So they're really two different issues. I don't think that record companies would ever support a levy system as a substitute for the kinds of distributions that a company like XM or somebody else is doing. The pennies that they can pay through a license by going to the record labels and publishers and others to get the license that's necessary to make that distribution, just like Sirius did, for example, which had a similar device. So, the HRA at this point has caused probably more problems because people try to twist it into something that it's not than it has, been a benefit. And I think most in the recording industry would probably say, let's just repeal the thing. It doesn't. It doesn't. Right.
Well,
So
at the time, though, it was an important.
Thank you. There was a question there, yes? More comments.
Yes, Phil Perkins with Music Services. My question concerns the pass-through provision that was afforded to the DSPs, digital service providers, that allowed them to quickly ramp up when they made deals with the record labels and pay the record labels for mechanical uses as if it was a physical product. Under the new legislation that is being discussed in Washington, is it likely that this pass-through provision will continue?
Well, again, I think it's part and parcel of what the system is that's ultimately developed. From our perspective, the most important thing is having some system that enables services to launch. If a service needs to rely on a record company or somebody else to help them get the license in order to launch because their expertise is not in clearing licenses and building that kind of infrastructure, we think that option should be available. But if you had a simple enough system where you basically had a blanket-like approach with a single designated agent or some catch-all general agent that basically did all of the work that the publishers currently throw onto the record companies and the DSPs. I mean, in most situations, the collectives, and this is the way it is in Europe, you send a report, and the collective is the one that figures out, who to pay and figures out the splits and divvies up the money, and they send an invoice, and that's just how it's done. Here, you have a very different system where the record company in the physical world traditionally, and the DSP in the new world would be in this never-never land of waiting for the composers, the one whose license it is that these companies want to take, to figure out what the splits are, on a regular song, on a song that has a sample or something else. So I think if you move to a simple enough system, it would probably take care of the direct licensing issue. It wouldn't become an issue. I mean, the record companies are not fighting for it for the sake of fighting for it for control. They want to be able to have a system where things get done quicker and get to market. And if you've got an Apple in the U.S. basically saying, I don't want to do this. I don't want to get into this business. It's not my expertise. It's going to cost me money. It's completely redundant of what the record company already has. Why should we create this inefficiency in the market?
Charlie?
I can answer that. I mean, the fact is that not having privity between the and music is an awful situation for music publishers and songwriters because there's no way to audit. And I've only read this. I've never actually seen it in practice. But record companies sometimes don't account correctly to copyright owners. So, that is a problem.
So let's create a system where the publishers and the composers take on the obligation to actually do the licensing completely, and then they have the privity and the audience, the audit rights.
That's what we did.
But that's not what's happened in the U.S. so far, unfortunately.
We have two requests from the floor. We'll take it in. I didn't see who came first, but we start from here and go upwards. So absolutely.
The Jew. Yeah.
Thank you. My name is Eddie Schwartz. I'm the president of the Songwriters Association of Canada, and I also work with SOCAN, the Canadian Performing Rights Organization. I'd like to thank Charlie for his kind words earlier. I want to make a comment about this notion of piracy and David Baskin's comments about, file sharing, trading. We don't want to legitimize the activity by giving it, the wrong nomenclature. I think the notion that Jack Sparrow is, Captain Jack Sparrow is doing all the downloading is a little misleading. For those of us who write songs and are artists, we call those people our fans. And the notion that they are the enemy, I think, is a horribly flawed, kind of underpinning to this whole conversation. And I have to say, on behalf of the artists and the songwriters, I think we really take issue with that whole notion. The idea that a business would sue its customers and make that the basis of their business policy going forward, I think we find remarkable and counterproductive. I think that the P2P is a revolution in distribution. It is now embraced by something, according to Steve Jobs, it is north of 90% of the people who engage in the digital universe. So the idea that as an industry we wouldn't embrace this as a new distribution model and find a way to monetize it, I find extraordinary. And although I applaud the efforts of David and all of you to monetize the small corner of the digital universe that is legal, I think it would be insane to own a store and say we're going to monetize 3 or 4% of the activity and let the other 97% walk out the door free. So I think, as speaking on behalf of creative people, I think there is a real disconnect here, and I just wanted to express that to the panel and get some comments on that.
Yes, please.
I was just going to say, I don't think there's really a disconnect. I think everybody up here is in agreement with that. Suing people is not a business strategy, but you've got to have willing business partners on the other side of the table to take licenses. And all of the people that have been, or services that have been subject to the litigation, I've talked to Mark Thornton. He's not interested in a license. He's interested in profiteering for however long he can off of the activity that is existing right now. He doesn't want to share the money that he's making off of it. And it was the same with other services that we unfortunately had to invest a lot of money in litigating against. So it's not, there are P2P services that have been licensed, as walled gardens, but they haven't been successful because they stand alongside other services that people are using and that they can get for free. And so you're right, the two have to kind of work hand in hand. The litigation is not a means to an end or a business strategy. If it were, it'd be a completely flawed and losing one. What we've tried to do is to, while new models are being developed, to educate. It's an education in deterrence program more than anything else. And we started that program, which we did very reluctantly after trying to educate without any kind of deterrence for many years. The survey showed that 73% of people said that doing that kind of activity was legal, and 27% was illegal. It's completely flip-flopped now to basically 70, 75 to 15. You had growth at the time that was even with the growth of broadband. Broadband has now obviously continued to go like that, but the file sharing, while still tremendous volume, has leveled off. So some of it is working at least in the message, but you're absolutely right that moving people over to legitimate services is what has to happen. But you've got to have the willing partners on the other side to do that.
Eddie, could I say that yesterday I said that ISPs were selling rags and gasoline outside a burning lumberyard and taking no responsibility for the conflagration. I think that music publishers would license a monetized P2P system in a heartbeat if it could be effective, if it was big enough. But quite frankly, what we're up against before that happening is that the telecom industry will lobby with all its might to avoid being saddled with that. Now, it takes some leadership from government and a lot of nations to realize that you don't deal with a problem by ignoring its source. The source of the problem is that the means of infringement are in the hands of users in unprecedented ways. Of course, the users aren't the enemy. Of course, the fans aren't the enemy. But the music business was not ultimately built on letting the fans have everything without compensation. Most songwriters want to eat regularly, so do most of everybody in the music business. The answer is to build the political and the social will to say that the tools that are making infringement and unlicensed and unpaid use a reality should be addressed, and that the payment structure should go on that level. We're doing what we can right now with the tools that are in our hands, and I think publishers would gladly support better tools for addressing the uses that are going on.
Yes, Charlie, and I'll try and get the last question there, but we are soon running out of time.
One sentence just to support Steve on this. Sean Fanning was approached 12, 15 years ago by NMPA. I sat across the table from him and had exactly the same experience. Will you take a license? Will you talk to us about negotiating? No, we're really not interested. We just came up to see what it looked like.
But he's changed now, hasn't he?
Snowcamp, yes. Going into business, I believe, isn't it?
That's right.
You? Yes, sir.
Michael Sukin, lawyer again, and I have a question I think directed at David, but I'd be happy to have it from answers from anybody. And it goes back to your presentation. One of the most troubling things, and congratulations on what you had to go through, but one of the most troubling things that I saw was the line there that indicated that I think it was Apple, Napster, and the telcos lined up with Sony BMG as the opposition.
In fact, all the record labels.
All the record labels.
All the major record labels, not the Canadian independent record labels.
So what we're presented with here as an audience is the very charming picture of effectively a publisher's representative, a songwriter's representative, a recording industry representative, somebody from the online world, and the government, sitting there looking like a very charming picture of unified grace. And in fact, what we see, and what everybody in this room, I hope, noticed, was the minute a contentious issue came up, there was a dispute, with a pretty serious dispute, and possibly with the government sitting there saying, why can't these guys figure it out amongst themselves? And actually, we have a digital company there who actually pays and licenses, an amazing thing. But let me just answer my question. My question is this, and you see shifting alliances on almost every issue. You see it in here. I've seen it in Europe. I see it in Japan. What are the chances of we, who effectively are the content holders, where the real trouble is often caused by those who use, what is the chance of you getting together and actually figuring out a way to solve these problems on a joint level?
Well, first of all, Michael, we're all lawyers, okay? Well, for the moment, pro tem. We're in a law school. You're dealing with...
I don't mean that critically, by the way, as Charlie would say.
I would never mean it critically. Lawyers are nature's own naturals. The bottom line is that you're looking at a dispute over scarce resources. The amount of money that's paid in a paid system for users to consume music is, by its nature, limited. You're not going to easily achieve an agreement between competing parties about dividing the pie. We tried to negotiate directly with the record industry, and we got nowhere. We used the Copyright Board's resources and services because that was the most effective way to get a conclusive answer to the question. But the real reason we had this fight, and why RIAA was up against us in the hearing, is because Canada is an economic subsidiary of the United States. The deals were all made first in the United States on the basis that, hi, we're the labels, you're the online services, you pay us X pennies on the dollar, we'll take care of the rights. So the concept that came across the border was a deal in which all the pennies that were paid net of the dollar by the online service to the record company were for the record company. And naturally, they're going to resist giving any of those pennies to anybody else. It's just human nature. We're never going to get rid of that. What we need are effective tools to resolve those disputes. And although the Copyright Board process was complicated and challenging and an expensive one, it delivered a result, which I can tell you from 20 years of negotiating against record companies for mechanical licensing, you're never really sure. Deals don't get closed. Arguments don't get resolved. One of the attractions of going to the Copyright Board is that, like all forms of litigation, it does represent a risk. You can't guarantee the outcome in advance. You may not get what you want, but you will get an answer. And this system and this industry will not proceed until these seemingly irresolvable dilemmas actually get answered. And so that's why we did it. Disputes are going to happen. You've got fights over scarce resources. We got the issue settled. Look at us now in Canada. We're now going to see online services with the record labels to say, let's build the business.
Thank you for these words from the cold little land to the north. Folks, let's hear it for the panel. Mr. Masouillet has signaled to me that there's now coffee break, and